Hello everyone, this is Prem Sodani coming up with the new session of our new Simplified, and in today's new Simplified we are going to discuss a very landmark judgment of Supreme Court of India, especially on this UAPA, that is Unlawful Activities Prevention Act, right? So let's get started with this act. This is the editorial which we are going to discuss that has come in the Hindu, right? So first we'll discuss about the background. What is the background? So in Kerala, 3 students were charged under UAPA, that is Unlawful Activities Prevention Act, and they were framed under the sections of 39, 38 of UAPA, and there are also provisions of some provisions are there in this particular act, that is UAPA Act, which are very draconian in nature, right? So what is this judgment all about and what are the provisions? We will discuss one by one. So what is the background? I was telling you that one. So background is these 3 students were charged under UAPA Act, and some of the literature was found with them, that is radical literature, that is caste issues in India, and a translation of the dissent notes written by Rosa Luxemburg to Lenin, and some of other type of literature which is considered generally radical in nature. So these things were found with them also. So when they were charged under this UAPA, and their case was then went to the Supreme Court finally, and Supreme Court came up with a judgment, and we will discuss that judgment, that is Thwaha Fasal case. And what is the landmark in this judgment? We'll discuss that thing also. So first we'll discuss what are the problems with UAPA Act, right? That is Unlawful Activities Prevention Act. So in this act there are some provisions. The provision first is section 38 and 39. So if a person who is a member of terror outfit, then he will be charged under this section 38, and if he is supporting the activities of a kind of terror outfit, then he will be charged under the section of 39, right? So these two are related with the terror outfits, right? And one more section is there, that is 120B section of IPC, Indian Penal Code, that also says if somebody is involved in criminal conspiracy against our nation or against the state, that will also be charged under section 120B, right? So this is the IPC, and these two sections are of UAPA Act, okay? Now we'll talk about this section 43D2, and this is the most draconian feature of this UAPA Act. Means if somebody is charged under UAPA, then he can be sent to the jail for a period of 180 days, even without filing a charge sheet. It means mere fabrication of the charges are sufficient to put anybody behind the bars for a period of 180 days. And what is more important here is, this is section 43E, and this 43E section explicitly mentions that if a person is charged under this UAPA provisions, now he is assumed that this person is a guilty. Otherwise, in cases of criminal procedures in India especially, or in everywhere in the parts of the world almost, if a person is charged with some allegations, he is innocent till he is proven guilty, right? But in this case, the presumption is that the person is guilty, right? And the burden of proving that I am not guilty falls on me. Means if I am charged under this UAPA, now the burden of proving that I am not guilty falls on the shoulder of myself. Okay? So this is the provision, and this is the most draconian provision again. So here we have 3 important cases related to the UAPA, right? So we'll discuss one by one. The first case is Jahur Ahmad Shah Watali. So in this case, Supreme Court has given this judgment in Jahur Ahmad Shah Watali that the burden of proof is on the of not guilty is on the accused, and bail was always denied. Means if you are charged under the UAPA's provision, bail is not provided to you, but jail is provided to you for sure. So this was the judgment of Jahur Ahmad Shah Watali. Okay, so you might have heard the names like Stan Swami, Sudha Bardwaj, Siddiqui Kappan. They were all framed under the provisions of this UAPA, and they were continuously denied the bails, है ना? And these were the people, those were charged under this UAPA. Okay. Now we come to the second case, that is K.A. Najib case. Here the important judgment was like no provision of any act prevents a constitutional court to provide a bail to a person, especially if the fundamental rights of the person are being violated, or we can say the bail was seen as a fundamental right for everyone. We can also say that thing also. So the bail was now can be provided by the courts, and the basis was the fundamental rights. So this was the second important case, that is K.A. Najib case. And on the basis of this K.A. Najib case, this third case of this Thwaha Fasal versus Union of India case was built upon, right? This was the second case of this K.A. Najib, where the bail was granted, and this was said by the Supreme Court that we can also provide the we can provide a bail to anyone. Any of the court can provide bail to anyone. The basis was fundamental right. In this third case, the more and more liberal interpretation was done, especially of the provisions of UAPA. Otherwise, these interpretations were very illiberal, very draconian under this Jahur Ahmad Shah Watali case. Now they were liberated, and especially these things were said कि if you are charged under the provisions of UAPA, now the bail can also be provided to you. And the second thing is said here is the section 38 and 39 can only be imposed to a person if he is preaching the ideology of that terror outfit, or he is furthering the cause of that terror outfit. Mere association with that ideology does not put someone under the framework of this UAPA. Right, so this was the judgment under this Thwaha Fasal versus Union of India. Means now if a person is charged under UAPA, now he can be provided a bail, otherwise which was denied in each and every case almost by the courts, right? So now this bail can also be provided to these people. Especially we can say these political prisoners now can apply for the bails, and they can also be provided with the bails, right? So this is the important case of Thwaha Fasal versus Union of India. I hope you might have understood what is this case all about. Now one more thing I would like to discuss here is, if these type of cases are coming in front of the courts has two options. The one option is the mechanical reading of the provisions of act, right? Means just read them mechanically and imply them whatever it is written in the act, even if they are violating the fundamental rights of anyone or of anybody, right? So this is the mechanical reading. So now you can relate that this was the process used in Jahur Ahmad Shah Watali case. Means mere mechanical reading was there in cases of judgments under this in case of judgment under this Jahur Ahmad Shah Watali, because it was written in UAPA that the bail will be denied to a person, and that was directly implied in this case. But now the second case is the constitutional reading of the provisions of particular act. In this constitutional reading, it is very much important to consider the fundamental rights of a person also. Means the fundamental rights are also taken into the care by the court, right? And now this second approach, you can easily see this approach was used in this Thwaha Fasal versus Union of India case. It means it is the fundamental right of anyone to have a bail. Okay, so this was the basis of this Thwaha Fasal case. I hope you might have understood all the case of this case of Thwaha Fasal and what are the provisions of UAPA Act, right? So this was all about this editorial. We'll meet in the second video, in the next video. Till then, bye bye, and thank you very much for watching this video. You can even share and like this video also.
Current Affairs by ForumIAS is an all-in-one program that covers the dynamic aspect of the syllabus from both prelims and mains perspectives. Last year, we have helped more than 100 students crack IAS with our current affairs classes.